We also have some other interesting things that came out from the court today from the state. This is the state's notice of jury instructions. So it looks like in Georgia they call this the state's request to charge. And so you can see each one of these different charges. All they're doing here is they're basically asking the court to take notice of the jury instructions. So when you go to trial and you have a jury sitting there, both sides are going to present their evidence. The government's going to go first. The defense is going to go second. We're going to have our opening arguments, present our evidence, have our closing arguments. And then the jury is going to have to take those facts that they just listened to, and they're going to have to apply the rules to the facts. And so there can be a lot of argument over, what are the rules? Like, what is the jury going to be looking at? What are the documents that they're going to compare the facts that they just saw in trial to? If this is the law and these are the facts, they're going to need to hold the two side by side and say, yeah, that looks like he hit the facts that were in this law, and that's going to be guilty. And so they need to know, what does the law say? What do the rules say? And so this is what the prosecutor's office submitted to the court. That would be their proposal for the jury instructions. And they are including the murder definition. So they're including malice murder, which is intentional murder. And this is what they're going to be instructing the jury. They're going to say a person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. And so this is the rest of the statute. It says down here, Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Yet if malice is in the mind of the accused at the time of doing the act or killing and moves the accused to do it, such is sufficient that okay. So you see what's happening here. You've got all of this language. This is all being proposed by the prosecutor's office. The defense has an opportunity to come back and say, actually, you know what? We don't like that explanation of the law at all. Maybe they come back, and I don't practice law in Georgia, so I don't know the specifics here, but maybe they'll come back and say, well, yeah, we actually disagree with this. We think Georgia law, we think this statement that it does not require premeditation, we think that's a little overbroad. We actually think that it may actually require premeditation. So they can argue over these jury instructions, and then the judge will ultimately, be the final arbiter of that, make a decision. And then when the jury goes back into the deliberation room, they're going to have these sort of agreed upon jury instructions that they can refer to when they're going to be making their decision as to whether the McMichael's or innocent are guilty. So they are including the malice murder. They submitted a ton of jury instructions over in this case. So we'll see where that goes. We also have a scheduling order. So we have some idea on when more stuff is going to be happening in this case. And it's coming up in October, November, and December. We had some earlier deadlines, but the defense, so the attorneys for the McMichael's, they actually asked for significantly more time. They wanted additional time to review all of the evidence that they have been given. So the prosecutors would have given them a lot of material, and they said, we don't have enough time to review all this stuff. And so they filed a motion, and they sort of detailed a lot of the materials that they got. And it is a ton. It is a lot more than the public has any idea. And so let's take a look at what they included in their motion. So they said that the state gave them the first round of discovery. Remember, discovery is the evidence. During the week of July 19th, the first round existed of 47.3 gigabytes of data. That is 1,600 pages, 1,635 pages, and it consisted of video interviews, police body camera videos, cell phone extraction reports. So they pulled out all these different files, 489 media files. And then there's going to be a second round of discovery, which is going to be even bigger. It's going to be about 5 times the size. The state will provide a second round of discovery consisting of about 260 gigabytes of data within the next day or so, which is a ton. I mean, that is a lot of material. Now, this is a big case. There's a lot of witnesses, a lot of calls, a lot of interviews, multiple defendants. We have a dead young man, and there's a lot to review. I didn't expect it to be that much stuff, but there's a lot. And so the defense asked for some additional time, which of course is absolutely reasonable, right? You want to make sure that the McMichael's have the best opportunities to review all of the evidence and to build their defense and have their day in court. This is due process. This is how our system works. And so the judge actually did grant them some additional time. Here is what we've got. We've got the final order comes from this is the order, this is a scheduling order. And so you'll see here a couple different dates. We've got the defendant's deadline for providing discovery shall be October 30th. So that means that the defense has to tell the prosecutor about the evidence that they have. We have another deadline on November 30th. So that's going to be the defendant's deadline for filing what are called pre-trial motions. And then all responsive pleadings shall be filed by December 31. So we're going to start to see some action on this case. We may actually see some results or some indication of what's going to be happening by the end of this year, which I think is on track. Now, I don't expect for this case to be closed this year. Normally, I would say these cases take a year to 2 years to resolve. And so if this extends literally into 2022, I would not even be surprised. But it does sound like the judge is holding this pretty tight. They asked for more time. So they asked everything to even be pushed back further than this, the defense. And the judge said, no, we're going to give you, we'll say till the end of October, but not until the end of November. So we're going to give you another 30 something days, but you got to get moving on this. And so they really got, there's a lot of work to be done. That is a ton of discovery. So hopefully they have everything they need to do that. And then all of the pretrial motions need to be filed by the end of November. So the defense, when you're in a criminal case, you can file what are called pretrial motions. So you can say, I want to exclude that cell phone record, or I want to suppress this evidence, and here's my basis for it. So all of those types of motions need to be filed, and they need to, disclose their witnesses, their experts, and all of that stuff by October 30th. So this case is going to continue to develop, and we are going to follow this one along. I think this is going to be interesting. We're going to see what happens, because we have a former police officer, former investigator, who's being charged with a crime, in my opinion, in a very friendly county. He worked with a lot of these people for a long time, and I know they're bringing in outside sources and other agencies to help and assist in the prosecution, but we'll see what ends up happening there.